Labor battles, like the seasons, go in cycles, and wage hour and overtime litigation is in high gear.
So there's a variety. It is the hottest area of litigation at the federal level by far.
The battleground, so to speak, is quite broad. You can go from anywhere from misclassification to overtime to gratuities.
The biggest trigger is the Department of Labor dramatically expanding who gets overtime pay.
What they've proposed to do is taking it from a level that's around $21,000 a year to taking it to a level in excess of $50,000 a year. So it's more than a 100% increase, which is of concern to a lot of employers.
If these new proposals go through, you'll have a lot less litigation. It'll be clear because anyone who is paid less than $50,000 will not be exempt from overtime.
But as employers are finding out, even well-paid employees may be eligible for time and a half.
Did a presentation to administration and said, look, you guys are severely underpaying.
Charles Goldich is a highly skilled, well-educated physician's assistant, earning a six-figure income, aiding doctors with intricate cardiac surgery. But when it came to working overtime, his hospital employer told him,
we were not going to pay you time and a half for your extra hours. I had always thought, is this really kosher? But I didn't know if I had any precedent or labor law to stand on. And I just looked in the mirror and I said, no, this is wrong. This needs to be corrected.
So Goldich filed a collective action and won. The court finding that physician's assistants are eligible for overtime because they're not members of traditional professions of law, medicine, and teaching.
And a physician assistant, by definition, does not practice medicine independently.
And while overtime issues are hot, litigation is also booming over this simple question. Who gets the tip?
How long have you been here?
A month and a half.
Good tips?
I don't make tips.
Serious? So where do the tips go?
The owner.
I can't believe that.
There's some pending against some hotel chains. So the claim is, let's say for a catering service or a banquet, there's a mandatory gratuity on the bill, and the allegation is, well, that's not being passed on to the servers. And does it have to be?
We're finding that this is unfortunately standard industry practice, is that the hotel is skimming these gratuities and not remitting them all to the employees.
And looming large on the horizon is the Uber class action lawsuit. Is someone classified as an employee or an independent contractor?
The biggest things that we're talking to employers about are when you classify somebody as an independent contractor, not an employee, it has tax implications, which means the government is not getting its money.
And if the government isn't getting its money, the Department of Labor will be watching, making employers skittish.
I would tell employers and corporations really the same things I tell my kids, which is always do the right thing. If you pay your employees the right amount of wages, you won't get in trouble, which is really a fair day's pay for a fair day's work.
There's a real issue in this country with classification. Who is a salaried professional? Who is entitled to overtime pay? Who is an independent contractor? These issues have blossomed into national litigation and class actions. How we define and pay a large class of employees in this country may be changing. For the American Law Journal, I'm Gina Passarella.